Item 501.
Wait, please. But I'll start with answering the question, my lord, which your lordships posed. I'm sorry.
Mr. Solicitor, we were wondering that if we go to your written submissions
Yes,
and you can really take us to your submissions, and then wherever you want to sort of break off from the submissions, you can emphasize, or you want to read out something else.
I shall do that. I shall do that.
That might be a good idea. So that we
That might, my lord. My lord, I can assure your lordships one thing. Lord, yesterday I again went through my written submissions.
Yes.
And there are certain portions which I feel should just be flagged and not read.
You can tell us that.
I'll, my lord, not take your lordships through that so that there is no wasting of the court's time. Lord, for the Lord, the question your lordships are examining, Lord, I must answer that question first, Lord. Flag that question first. Your lordship's question was, who appoints and who posts the officers in the GNCTD? Lord, my answer would be, and I would substantiate at the end, entry 70, list 1. Please see, my lord. And then, my lord, I'll immediately go to the written submissions. Entry 70, list 1.
Yes.
That's your lordship, sir. Union Public Services, All India Services, and Union Public Service Commission. Lord, I would show from the rules that all these, except DAS, Lord, which is class 3, class 4, etc., are all India services. Kindly park that, Lord, undisputed position on the side.
17, right? 170.
70, Lord, I'm sorry. Entry.
Union Public Services, All India Services, Union Public.
Yes, Lord, all are all India services under the rules framed by the President in proviso to Article 309 of the Constitution. And those rules provide for, Lord, all mechanism, appointment, posting, etc. But, my Lord, that I will come subsequently. My Lord had some.
Yes.
No, I got the point.
Lord, your lordships would essentially be answering the question, my Lord, whether the term services would be hit by the phrase insofar as it is applicable to the union territory.
Yes.
Because, my Lord, your lordships are not deciding the question regarding the capital of the nation, and which will have far-reaching ramifications for the nation, my Lord. Therefore, slightly your lordships may require a historical background as to how Delhi was conceptualized and eventually constitutionally provided for in a different governmental framework. There is a different, my Lord, framework provided, and there is a history behind it. Lord, kindly come to, Lord, one judgment. Lord, I'm sorry, I'm reading this judgment at the outset, but it's not on the question. It's on question of Delhi. What is the significance of Delhi? And therefore, my Lord, thereafter I'll take your lordships to the, Lord, kindly come to para 2 of my written submissions. Lord, right now, your ladyship, my lords may kindly take only the written submissions. I'll not go beyond this. And there also, my Lord, I'll skip what is not relevant. Everything is relevant, but what need not be read. I'll my Lord, put it that way. Page 2, Lord, the judgment in Jagdish Sharan versus Union of India. The Justice Krishna Iyer's judgment, as the language would immediately, my Lord, make it clear. Para 10.
One.
Pardon?
Para?
Page 2, para 5, judgment para 10.
Yes.
Is a quotation.
Yes.
The capital city is not just a part of India. It is miniaturized India. A fact often forgotten by the administration in the field of culture and education, especially vis-a-vis regional minorities. It is megapolitan and people from all parts flock to this outsized city. But we cannot exaggerate this factor. For the presence of the farther regions like South and Northeast population wise is minimal and precarious. Sri Balakrishnan, the learned council, not the report, Balakrishnan report, not that Balakrishnan, insisted that university was sustained. Your Lordship can skip. We may, then para 56, we may wind up by articulating the core thought that vitalizes our approach. Anyone who lives inside India can never be considered an outsider in Delhi. The concept that people of Delhi has a right of will, etc., etc. Delhi is a cosmopolitan, not just cosmopolitan, it is miniaturized India. It belongs to the nation. It belongs to the entire country. Now, Lord, let's see, Lord. Now, kindly come to para 3. Historically, my Lord, why this would be relevant? Because your Lordships would be examining the chapter of services. And when your Lordship examines the chapter of services, your Lordships will need the distinction between the historical part A states, part B states, part C states, and part D states. There was a distinction which was, my Lord, eliminated, and thereafter, my Lord, now Delhi is formed not from part A and part B, but part C. The relevance I'll come to later. Kindly come to, my Lord, historical background, para 8. It is submitted that Government of India Act 1935 recognized in the circumstances in which it was enacted 3 categories of components of erstwhile union, namely governors' provinces, federating Indian states, and chief commissioners' provinces. Kindly note here, my Lord, at this stage, Delhi was a chief commissioner's province. It was not a federating state. Lord, this classification was reflected in the grouping of states of the Indian Union as part A, B, C, and D states after independence and after Constitution came to be framed. Therefore, when the Indian Constitution was enacted, there were 4 categories of states known as part A, B, C, and D. Lord, you'll also take it from me that Delhi was part C state. There would not be any dispute on this factual problem. We differ on the interpretation of the Article 239 AA. This fact is not in dispute. Lord, before the Constitution came into force, and even before the independence, Lord, at the request of the Constituent Assembly, a committee was constituted. That was Patabi Sitaramaiah. Lord, an eminent tall leader, my Lord, of his time, my Lord, an eminent Congress leader, my Lord, just incidentally, he fought against against Subhash Chandra Bose as a president of Congress and lost, though he was sponsored as a candidate of Mahatma Gandhi. But he lost, my Lord, the Subhash Chandra Bose one. Nothing to do with the matter. Lord, I'm not reading the entire recommendations. Kindly see E. Center must have special responsibility for the good government and financial solvency of the. For Delhi, this was, my Lord, Delhi specific commission, and they say that Delhi being the capital, I'm not going into, my Lord, the details which ultimately reached into this conclusion, but they say, the committee says, Delhi must have special responsibility because it's a capital of that, belongs to the nation. The nation is known by the capital. Now, my Lord, the Constitution comes into force, and your Lordships may kindly see para 13 at the foot, Article 1. India, that is Bharat, shall be a union of states. The states and the territories thereof shall be the states and territories specified in part A, B, and C of the first schedule. So, my Lord, India comprises of A, B, C. But in the first schedule, A and B were states, the way, my Lord, we understand, like Madhya Pradesh, Maharashtra, Karnataka, etc., etc. And Delhi was in part C. That fact, again, my Lord, is not in dispute. Now kindly come to, my lord, para 15 at page 5. Part C states had also been termed as centrally administered areas. They always have been, my lord, historically centrally administered, and that thread continues with variations till date. That's what, my lord, I am trying to respectfully drive at. The Part C state had also been termed as centrally administrative areas. Delhi, in addition to Ajmer, Bhopal, Bilaspur, Kurg, Himachal Pradesh, Kutch, Manipur, Tripura, and Vindhya Pradesh, was included in the list of Part C states. Now, thereafter, kindly come to the next page, page 6, Government of Part C States Act. Look, there is some relevance, my lord, to this. This, my lord, now Delhi came to be governed for the first time by a statutory enactment made by Parliament, namely the Government of India, Government of Part C States Act. Upon Constitution coming into force, the Parliament enacted Government of Part C States Act 1951 in exercise of the powers under Article 240. With Section 21 of the said Act, a statutory provision was made for the first time for Delhi to have a council of ministers and have a legislature comprising of elected representatives. With Section 3 of the Act, a legislative assembly had been created for Part C states. Section 21 had demarcated the legislative power of the assembly of Part C states. Section 21(1) had provided that the legislative assembly of Part C state could make laws with respect to any of the matters enumerated in the state list or in the concurrent list. However, insofar as the Legislative Assembly of Delhi was concerned, the proviso to Section 21 had specifically excluded number of subjects from the legislative competence of the Legislative Assembly of Delhi, including public order, police, land buildings, municipal corporations, etc. My lord. Now kindly turn the page over, my lord, and come to para 22. My lordships would notice, my lord, I am skipping other paragraphs which may kindly be read, my lord, whenever your lordships find at leisure, my lord. But I am right now not troubling your lordships with that. Para 22. Further, the proviso to Section 36(1) of the Act inter alia had provided that in cases of difference of opinion between the Chief Commissioner, or the earlier version of the LG, and his ministers on any matter, the Chief Commissioner shall refer it to the President for decision and act according to the decision given thereon by the President. Pending any such decision, the Chief Commissioner in any case of urgency was duly enabled, empowered, and could take such action or give such direction as it deems necessary. Lord, this is the counterpart of Article 239AA, sub-Article 4. Slightly differently worded, but in substance, that is what it says. Lord, thereafter, my lord, the Parliament appointed Justice Fazal Ali Commission. Please see para 24. In 1953, Fazal Ali Commission was charged with the task of reorganizing the states on linguistic line by the then Prime Minister. In the year 1955, the Commission submitted its report. Lord, so far as Delhi is concerned, kindly come to para page 10. What Justice Fazal Ali Commission remarked with respect to Delhi, which, please do not bear in mind, continued to be Part C state, not a full-fledged state, which it is not even today. But there is some other significance of it being a Part C state. Therefore, my lord, I am reiterating and emphasizing. Lord, page 10, your lordships have. Para 27. Lord, what? There are other, my lord, things also. Lord, I kindly come to, my lord, page 9 first for a, my lord, time being. Para 285 of the report. Taking all the, my lords have taken. Taking all the facts into consideration, we recommend that the component units of the Indian Union be classified into two categories: states forming primary constituents units of the Indian Union, having a constitutional relationship with the center on a federal basis. These units should cover virtually the entire country, and territories which, for vital, strategic, or other considerations cannot be joined to any of the states and are therefore centrally administered. Please see the thread which is running historically from the beginning, that there are certain areas which are so strategically located for various reasons. In some areas, defense strategic. For some areas, it may be some external affairs issue. In a capital like Delhi, it's a capital, therefore has its own strategy. And therefore, they say directly the center should administer. And therefore, Manoj, I keep repeatedly insisting that UT is nothing but an extension of union. It may have various shades. Some UT may have legislature, some UT may not have legislature, but ultimately the supremacy and control of the state is not only the need of the hour, had always been thought to be so. Now kindly come to Manoj, Delhi. Justice Fazal Ali Committee, Manoj, what it feels about Delhi, page 10, para 27. With regard to Delhi and its status as the national capital, it had been specifically observed by the Commission as under. It is hardly necessary to discuss in any detail the reasons why Delhi, if it is to continue as the union capital, cannot be made part of a full-fledged constituent unit of the Indian Union. Even under a unitary system of government, the normal practice is to place national capitals under a special dispensation. In France, for example, there is a greater degree of central control over Paris than over other municipalities. In England, I'll come to that, Manoj, if need be, my learned colleague, Mr. Faras's submission. In England, the police administration of the metropolitan area is directly under the control of the Home Secretary, who does not exercise similar powers in respect of other municipal areas. Apart from reasons which are peculiar to each country or city, there are some general considerations necessitating special arrangements in respect of national capitals. Capital cities possess or come to possess some degree of political and social predominance. They are seats of national governments with considerable property belonging to these governments. Foreign diplomatic missions and international agencies are located in these capitals. They also become centers of national culture and art. So far as federal capitals are concerned, there is also an additional consideration. Any constitutional division of powers, if it is applicable to units functioning in the seats of national government, is bound to give rise to embarrassing situations. Practice in other countries, administrative necessity and desirability of avoiding conflicting jurisdictions all point to the need for effective control of national governments over federal capitals. It may be recalled that the desirability of excluding the seat of central government from the jurisdiction of a provincial government was one of the main considerations which led to the transfer of imperial capital from Calcutta in 1912. Lordship may skip the rest, 589. It is conceded that the national capital has to be under the effective control of national government, and both New Delhi and Old Delhi have to be treated as a single unit for administrative purposes. There will be a little scope for difference of opinion on its future administrative pattern. Lord, kindly turn the page and come to page 591. In devising a system of government for Delhi, therefore, we must take into account primarily the requirements and aspirations of cosmopolitan urban population. Urban problems such as slum clearance, reconstruction, city planning, recreation, transportation, and primary and secondary education all fall within the domain of municipal finance and enterprise. If we were to guide, we are to be guided by these clear considerations as well as by the experience of other advanced countries. Municipal autonomy for Delhi in the form of a corporation would appear to be the most appropriate method of meeting and reconciling the broader requirements of the national government as well as the local needs and wishes of the people. We have given careful consideration to the argument that a denial to the people of Delhi of the benefits of popular government at state level would be a retrograde step. It has to be realized that if Delhi is to continue to be the seat of central government, it must adopt a model which is sound in principle and administratively workable in practice. People residing in national capitals enjoy an advantageous position and they must be prepared to pay some price for it. It may be pointed out that the legal residents of the District of Columbia in USA, are at present totally disfranchised. Then they say that that should not happen. Last three lines. We are definitely of the view that municipal autonomy in the form of corporation, which will provide greater local autonomy than is the important federal capital, is the right and in fact the only solution to the problem of Delhi. Thereafter, my lord, final recommendations are given in the similar terms. Now, my lord, comes the Constitution 7th Amendment. For the first time, my lord, the Constitution is amended based on the report of Justice Fazal Ali Commission. And the concept of union territory comes, and this is, my lord, very, very relevant. But for this reason, when your lordships would examine the constitutional provisions, particularly with respect to services, your lordships would find that there are several amendments made through Constitution's 7th Amendment Act. The constitutional amendments have made provisions by way of amending service provisions, but there is a conscious decision to keep the union territories out. To put it differently, for the first time, the concept of union territory constitutionally comes under the 7th Amendment, with other amendments under the 7th Amendment. But union territory is given a separate treatment and not the treatment which is given to other federating states. Lord, kindly see. Article 1, my lord, this is now post-amendment. India, that is Bharat, shall be a union of states.
1 minute. Which page?
I'm sorry, my lord, page 12, para 30. This is reproducing, my lord, the Article 1 post 7th Amendment, which was based on the report of Justice Fazal Ali Commission.
Yes.
India, that is Bharat, shall be a union of states. The states and the territories thereof shall be as specified in the first schedule. In the first schedule, there was an amendment where Delhi and others were shown as union territories, rest federating states. The territory of India shall comprise the territories of the states, the union territories specified in the first schedule, and such other territories as may be acquired. We were very, very ambitious even at that time that we might acquire some more territories, which of course we did acquire, not in the sense of invasion and acquire, but Sikkim came in 74. Thereafter, I have given, in a tabular format for your lordship's convenience. What happened in 7th Amendment, pre-amendment position on the left column and post-amendment position on the right column. But your lordship will not kindly come to page 21 direct.
Yes.
Lord, this may kindly be read a little closely. Your lordship knows, my lord, the provisions of services is made in part 14 of the Constitution of India. Part 14 came to be amended by 7th Amendment. That is the lordships would find at 308, my lord, the bottom foot of page 21. Left hand side is pre-constitution, right hand side is post. Interpretation. In this part, unless the context otherwise requires, the expression state means a state specified in part A or part B of the first schedule.
Page 21.
I'm sorry, your ladyship, it is page 21 at the foot, article 308, which is the first article in part 14 of the Constitution. The heading is services. services of union and the states. Why, my lord, I show this for three reasons, which I'll, my lord, assist your lordship with subsequently. Lord, before the constitutional amendment by the seventh amendment, interpretation was in this part, unless the context otherwise requires, the expression state means a state specified in part A or part B of the first schedule, meaning thereby, even before the constitution, for part C states, there was no separate service contemplated, which now becomes steril. It was only for the federating states. Now, when the constitution was being amended under Seventh Amendment, and the concept of union territory was being introduced, if the framers of the constitution by the parliament wanted to have a separate union territory service, it would have done so, because this is amended simultaneously. Seventh Amendment introduces union territory and also amends 308. Now see what is the amended provision of 308. Right hand side. Interpretation. In this part, unless the context otherwise requires, the expression state does not include the state of Jammu and Kashmir. The state as defined under Article 1 under the 7th schedule, that is federating state. Only exception, Jammu and Kashmir, for reasons, my lord, which were prevailing before 2019. Jammu and Kashmir was always used to be excluded. Meaning thereby, the very amendment which introduces union territory does not introduce the term union territory in the chapter which is under the heading of services under the union and the states. So there is no contemplation of a separate service for union territory. Now, my lord, 309. My lord, let me read the pre-amended provision. Recruitment and conditions of service of persons serving the union or a state, subject to the provisions of this constitution, act of the appropriate legislature may regulate the recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the union or any state. Here, my lord, because of 308, state would necessarily mean federating state, not union territory. Nothing prevented parliament to say so. Now, proviso is relevant and will give guide, my lord, assistance to your lordships. Why? Provided that it shall be competent for the president or such person as he may direct in the case of services and post in connection with the affairs of the union. Lord, UT is affairs of the union, first of all. It's an extension of the union, but leave it at that. Next. And for governor or Raj Pramukh of a state or such person as he may direct in case of services and post in connection with affairs of the state to make rules, etc. Why, my lord, I am highlighting? Raj Pramukh was only for part A and part B states. There was no Raj Pramukh for part C states. When the constitution framers, my lord, I'm sorry, the parliament amends the constitution, introduces union territory for the first time by this very amendment. What it says, my lord, it doesn't say, it could have logically said if it intended to introduce union territory to have a separate service, that president for services for the officers under the service of the union, governor for services under the state, and administrator for the purpose of services under the UT. Kindly see, my lord, what it says. My lord, right hand side proviso. Provided that it shall be competent for the president or such person as he may direct in the case of services and posts in connection with the affairs of the union and for the governor, the Raj Pramukh word is deleted because now A and B states have gone. It became federating states, but no introduction of administrator. And I'll show administrator also comes along with UT by this very amendment. Governor of a state or such person as he may direct in so and so. Now, please see, my lord, in this very amendment, my lord, at page 230, my lord, page 13. The same amendment, seventh amendment, which introduces union territory, also now provides for administrator and does not include administrator in services, does not include union territory in services. Therefore, my Lord Justice Chandrachud, my Lord the Chief Justice of India, then my Lord said that you will have to read the entry contextually, whether it was ever intended to be given to union territory. And therefore, the word used in 239AA is insofar as the matter is applicable to union territories. Plural, I'll come to that. My Lord, that's a separate limb of argument. My Lord, kindly see. Unamended 239, administration of Part C state of the first schedule. Lord, the title makes it clear that Part 14 under the heading of services would not apply because it applies to states. And earlier it used to apply to A and B states. This is for Part C. Now kindly see how amendment is made, and that is, my Lord, on the right hand side. 239. Administration of union territories, save as otherwise provided by Parliament by law, every union territory shall be administered by the President acting to such extent as he thinks fit through an administrator to be appointed by him with such designation as he may specify. For Delhi, it's Lieutenant Governor. For rest, it is administrator. So, two things, again at the cost of repetition, and kindly pardon me for that. Union territory comes for the first time by this amendment. Administrator comes for the first time for this amendment. But the same amendment, while amending the services chapter, neither includes union territories nor includes the administrator. A conscious omission, a conscious legislative call that there would be union services and services of the state, not services for union territories. Now, your Lordship, my Lord, kindly now come to Lord, page 24. I'll just, my Lord, shuffle through this. I'll not read this, but just to complete, my Lord, the narration. In view of, my Lord, Justice Fazal Ali Commission's report that there must be given right to franchise in case of municipal matters like sanitation, etc., etc., Delhi Municipal Corporation Act 1957 is enacted. At page 24, I'm not reading, my Lord, the details. Then, my Lord, page 25, Constitution 14th Amendment Act. Kindly see, my Lord, para 42. Having carved out a separate unit of governance, namely Union Territory by 7th Amendment, the next question was what treatment should be given statutorily or constitutionally to the Union Territory of Delhi in view of its peculiar position as the capital of the nation. Next para, your Lordships may kindly skip. It must also not be lost sight that by way of the Constitution 14th Amendment Act 1952, in part Roman 8 of the Constitution enabling the Parliament to create legislative assemblies with Council of Ministers in respect of certain union territories such as Himachal Pradesh, Puducherry, Himachal Pradesh, Goa. Consequently, the Government of Union Territories Act 1963 was enacted by Parliament in the year 1963 for the government of such union territories. But for the first time in our country, there came to be 3 categories consisting of the nation. A, federating states, full-fledged states like Maharashtra, Gujarat, etc. Second, union territories without legislature. And third, union territory with legislature. That happened by an act of parliament. And something would turn when I respond to my learned senior, my Lord Dr. Singhvi's submission regarding, my Lord, that Puducherry has that, etc., etc. It is that union parliament's law which permits. My Lord, then your lordships may, there are salient features, my Lord, of Government of Union Territories Act, which I may not, my Lord, trouble your lordships with. Next is para 27. I'm sorry, page 27, that is Delhi Administration Act. But kindly see that only first para 48. In 1966, Delhi Administration Act had been passed to provide for an elected body of Delhi Metropolitan Council, which may propose, recommend legislations to be passed for Delhi. This had provided for direct election from different constituencies for electing metropolitan councillors. This elected body, to be known as Delhi Metropolitan Council, was in addition to the provisions for direct elections of councillors to the MCD under the 1957 Act. So for the first time, Lord, Delhi Metropolitan Council comes into existence, not the Legislative Assembly. That's all. That's the as a part of the narration. Now comes, Lord, the most important part. Lord, there was a wish, desire, and hope of the people that we must have an assembly. The Parliament, Lord, the government of the day, constituted a commission headed by Justice Sarkari. One of the members was Mr. Balakrishnan. Lord, incidentally, Justice Sarkaria completed virtually the substantial report. He worked for 13 long months, Lord, on this report. And thereafter, Lord, he was requested to be the chairman of the Press Council of India. And therefore, he demitted the office from the commission. Therefore, when the report was presented, it is known as Balakrishnan report, my Lord, but it essentially is a joint report substantially prepared by Justice Sarkaria. Nothing turns on that. It nonetheless is a report, but it is a report by someone, my Lord, having legal acumen and who has done a remarkable job, Lord, in his Sarkaria Commission report defining center-state relationship. My Lord, pausing here for a minute, my learned friend made extra efforts to ensure that your lordships do not go through Balakrishnan report. Lord, Balakrishnan committee report is necessary for two reasons. Lord, Balakrishnan committee report became the basis of the 69th constitutional amendment, which introduced 239AA. It is the basic foundation. That is number one. Number two, the then Home Minister, while introducing the 69th Amendment Bill, in more than one places say that this entire bill is structured based on the recommendation given by Balakrishnan Committee. And third and most important, my learned friend read only one paragraph from the majority judgment of Honorable the then Chief Justice Mishra, that we need not rely upon Balakrishnan Committee report. But I will show para after para. I'm not saying that I'll read. I'll show para after para that Justice Deepak Mishra relies upon it. My Lord Justice, my Lord the Chief Justice of India, in a separate concurring judgment, in detail relies upon it. And entire reading of the judgment, my Lord, in right perspective, would leave no room for doubt that your lordships have relied upon Balakrishnan Committee report to arrive at the conclusion. This is like, Lord, Parliament, Lord, Constituent Assembly debates as to what was in the mind of the framers. Because the Home Minister says we are basing this entire amendment based on this report. Now, please see, my Lord, the speech of the Honorable Home Minister. while introducing this 69th amendment, which brought Article 239AA, which we are assisting your lordships with right now. Lord, your lordships may kindly come to page 28, para 54. Does your lordships have that?
Yes.
The debates in Parliament while introducing the Constitution 69th Amendment Act leave no room for doubt. My Lord, I'll just reading. The speech of the Honorable the then Home Minister conveyed the following to the House. As the House is aware, Delhi is a union territory administered under Article 239 of the Constitution. 239 was there since 7th Amendment with administrator. Under the existing law, namely the Delhi Administration Act, there is a Metropolitan Council with elected members and an Executive Council to assist and advise the administrator in the exercise of his functions, other than those in which he is to exercise his discretion. The Metropolitan Council is only an advisory body with no legislative powers. There has been persistent demand for a representative form of government in Delhi and also for removing problems faced by the common man, such as multiplicity of authorities with overlapping functions. With a view to finding a permanent solution to the problem of the problems, the government appointed a committee on 24th December 87 under the chairmanship of initially Sri Justice R.S. Sarkar, but it should be Sarkaria, and subsequently Sri Balakrishnan with wide terms. Lord, I have given the constitution or composition of the committee at page 28. From the beginning, it is Justice Sarkaria as chairman, Ramesh Chandra, former Secretary Urban Affairs as member, and Balakrishnan, advisor to the Home Ministry as the member. So he was there, my Lord, from the beginning. Thereafter, my Lord, the Honorable, the then Honorable Home Minister discusses, my Lord, what is the, Lord, kindly see page 29, unnumbered para 3. It also examined, it means Balakrishnan Committee. It also examined the detail of the arrangement made in national capitals of other countries with a federal setup and took note of views expressed in the debates of the Constituent Assembly and Houses of Parliament on various occasions in regard to the arrangements for the capital. It also studied the recommendations made by the earlier committees and the commissions. The committee was aware of the complexities involved in designing a proper structure of government for a national capital, particularly for a country with a federal setup. Two conflicting requirements have to be reconciled. First, the requirement of satisfying the democratic aspirations of the citizens of capital to govern themselves in consonance with the spirit of the Constitution is very important. Secondly, as has been recognized the world over as well as in our country all along, the national government should have sufficient control of the capital city and its administration for discharging its national and international responsibilities and commitments. Further, the effective administration of the national capital is of vital importance to the national government for ensuring the requisite degree of security and administrative efficiency. In addition, there is the need to preserve the cosmopolitan character of the capital. The report of Balakrishnan Committee has attempted to design a government structure for Delhi, which would secure a reasonable balance between these requirements. The committee has come to the conclusion that on an objective appraisal of the aspects, any arrangement that involves the constitutional division of functions and responsibilities between Union and Delhi administration will be against the national interest and should be ruled out, and that, therefore, Delhi should continue to be a union territory with a legislative assembly with appropriate powers. It has also recommended that subjects of public order, police and land should be retained with the center as they are matters of vital importance for which the responsibility cannot be divided. This is also broadly in line with the provisions made in Government of Part C States Act 1951, enacted by the Constituent Assembly, sitting as Parliament. The details of the new arrangement for the national capital will be clear from the provisions of the bill, and I do not propose to go over the same. After carefully examining the report of the Balakrishnan Committee and considering all aspects, it has been decided to enact legislation generally on the lines of recommendation of this committee, and the bill seeks to make appropriate provisions in this regard. As the House may be aware, on earlier occasions, whenever a democratic setup was considered for Delhi, such as Government of Part C States Act, and also under the bill introduced in 1978, necessary provisions for a democratic setup were made under a parliamentary law enacted in performance of Article 239A. However, in case of Delhi, which is a national capital, the committee has recommended that provisions of the democratic setup should be incorporated in the constitution itself with a view to securing a measure of stability and permanence and also giving a special status to the national capital. Delhi as the national capital has a unique status and certain distinguishing features. In view of the importance for the country as a whole, it should inspire a sense of belonging to all the states, which cannot happen if it is located in the territory of or be controlled primarily by a single state. The arrangements made in this regard to the national capital in other countries, particularly those with a federal setup, and all the thinking that has gone into this subject so far, fully support the view that national capital should be under the full control of national government. Lord, this is precursor to 69th Amendment, which introduced 239AA. The Home Minister says so while introducing the bill. At no point in the past has it ever been considered possible to make Delhi a full-fledged state. The Constituent Assembly went into the matter in great depth. It was observed during the debates that in the capital city, a large federation like ours, the arrangement should be that in the area over which the federal government has to function daily, that is the national government, practically in all details, the government should have unfettered power which is not contested by another and subordinate legislature. This is the intention, and this is how, in my respectful submission, 239AA will have to be read. The States Reorganization Committee and all other committees have reached the same conclusion. Several important national and international institutions like the President, Parliament, the Supreme Court, etc., as well as all foreign diplomatic missions, international agencies, etc., are located in Delhi. It is also a place to which high dignitaries from other nations pay official visits frequently, and it is in the national interest that highest possible standards should be maintained in the administration of the national capital. It is also in national interest that the center should have control over the national capital in all matters, irrespective of whether they are in the state field or union field. Lord, I am not re-arguing the Constitution bench judgment. I am only confining this to the services and the control, my Lord, which the very foundation stone of 69th Amendment recognized. If Delhi is made a full-fledged state, it would be constitutionally impossible for the central government to intervene in any matter relatable to state lists, such as public order, public health, essential supplies, municipal services, etc. These are not illustrative. These complete constitutional prohibition will make it impossible for the central government to discharge its national and international responsibilities in relation to capital if Delhi becomes full state. Then 69th Amendment Act comes, which brings in 239AA. Now, this is, I'm sorry.
Yes.
Lord, this is the relevance of Balakrishnan report, and I will read it at the end using my discretion not to read which is not relevant, but to say that Balakrishnan committee report should be discarded may not be a correct assistance to the court. Lord, I am not relying upon, my Lord, I at the outset, my Lord, pointed that wherever word state is used, union territories, house state, that part of the commission I am not relying upon. That, my Lord, the Chief Justice of India has taken care, my Lord, in the Constitution bench. It has to be decided contextually, but to give context to the word insofar as it is applicable to union territories. Lord, your Lordship would examine whether a particular matter, Constitution doesn't use the word entry, particular matter is applicable to union territories. It's not in singular, it's in plural. Can Lakshadweep do that? Can Dadra and Nagar Haveli do that? That is the context, Lord, with special context with regard to Delhi emerging from the Balakrishnan Committee report. That complete control for various reasons. Lord, there has to be a lieutenant governor who is informed by the officers. Lord, nobody say the bureaucracy should be pliable bureaucracy. Lord, I personally had a very serious objection, though it was lightly said, monogamy, that permanent monogamy. No, bureaucracy is not wedded to any party, any government. Bureaucracy is wedded to the Constitution of India. But suppose national capital is under a siege. You take an example. National capital is under a siege. One arterial road, my lord, linking one section of the country to the capital is blocked with permanent structure. And if the government of Delhi sends food, it is the responsibility of the bureaucrat to inform the LG that this is the capital cannot be under the siege. That is the control, my lord, which is envisaged under 69th Amendment. If during the COVID period, the number of tests are brought down, my lord, with a view to ensure that the figure is good, it would affect, my lord, the future course of action the country would take nationally. The health secretary will have to bring it to the notice of the LG. That you cannot do that. At a particular point of time, the test has to be rigorous testing so that we know the real problem, whether we are dealing with a rat or with a dinosaur, so that the national policy can be accordingly framed. If we show only 10% are affected with COVID, though there are 500, Lord, we may have a situation where all high commissioners and ambassadors are affected, and the world over the message will go that the government of India is doing nothing. It is the national shame. Lord, therefore, I am not saying the bureaucracy should be loyal to the central government, but the central government must have a say who will be appointed and who will head which department. Then, as I have shown from the terms of business, he is bound by the transaction of business rules. He is reporting to the minister. He is taking orders from the minister. He is bound by the instructions of the minister. If there is any difference, it goes to the Council of Ministers. Council of Ministers is supreme. Collective responsibility, democratic functioning, everything is, my lord, I respectfully bow. But to say that once the officer comes under my jurisdiction, it's my decision what to deal with, how to deal with him, and what to tell him, that goes against the very spirit with which 239AA is introduced. Lord, now kindly, my lord, see, my lord, page 34, your lordships can just have a look. These are the judgments why the report which becomes the basis of a constitutional amendment is a good external aid for interpretation. I am not, my lord, reading it. Now, my lord, your lordships may come to 35. Your lordships have read and reread Article 239AA, but it would take 5 to 10 minutes, my lord, if your lordships allows me to read it, and your lordship reads it with me, the way, my lord, I perceive 239AA to be, which, my lord, gives the supremacy, not only to the parliament, but to the executive as well, because the executive function is always coterminous with the legislative function of the executive, my lord. Lord, 35.
Mr. Solicitor, instead of reading that, if you can just look at your para 67.
Yes.
You have highlighted some very important aspects of 239A. So we can read para 67 actually. Because you have paraphrased which are those parts of 239A which are crucial according to your submission.
Yes, my lord. Only one thing before that, with my lord's permission. May I read 3A only first and then come to 67?
All right. Yes, all right. We can read
3A at 35.
Yes.
subject to the provisions of this constitution. Kindly pause here for a minute. Lord, this includes sub-article 1 also, which reads, as from the date of commencement of the Constitution 69th Amendment Act, the Union Territory of Delhi shall be called National Capital Territory of Delhi, and the administrator thereof appointed under Article 239 shall be designated as the Lieutenant Governor. So, my lord, 239, original 239, which was brought in under the 7th Amendment, is applicable. Administrator does govern the Union Territory. And your lordships have accepted in the Constitution by judgment. Lord, 239 existed much prior to 239 AA, which empowered administrator to control or to administer the national capital, all Union territories. So that continues because it is subject to the Constitution, and which includes 239 and includes 239 AA sub-article 1. Then, my lord, further, 3A. I'm sorry.
Yes.
No, my lords are jotting. The Legislative Assembly shall have power to make laws for the whole or any part of the National Capital Territory with respect to any of the matters enumerated in the state list or in the concurrent list. Please mark, insofar as any such matter, not entry, any such matter is applicable to Union territories. Lord, plural. So the test in my respectful submission for your lordships would be a subject matter wise selection of implied exclusion. My lord, there are two exclusions under this. First is, my lord, insofar as any such matter is applicable to Union territories. That is implied exclusion contextually, as my lord, the Chief Justice of India has read, and I'll show my lord, those paragraphs from the judgment. That is implied exclusion from the subject matter. That this subject matter can't be in Union territories. And when you lordships test, it has to be whether Lakshadweep can do it, whether Goa, whether Div and Daman can do it, whether Andaman and Nicobar can do it. That would be the test. And second, except matters with respect to entry 1, 2, and 18, and so and so. Now B. Now, my lord, kindly come to 37, 37. My lords, my lord Chief Justice of India, my lord, very kindly indicated, para 67. A perusal of sub-rule 3 would show that the extent of legislative powers of the Legislative Assembly of NCT is consciously, unequivocally, and manifestly circumscribed by 5 modes. A. My lord, I have already pointed out, subject to these provisions of the Constitution. That is, administrator, govern Union territory, continues. And 2, the legislative power of Delhi government, Legislative Assembly to be in the, be it under state list or in concurrent list is circumscribed to the extent insofar as any such matter is applicable to Union territories. So, my lord, in other words, the legislative power of Assembly cannot extend to any of the entries in the state list or concurrent list if the state entries are not applicable to Union territories. It does not use the expression in relation to Union territories. It says applicable. My lord, applicability test is a rigorous test. It should be applicable. Relating to is a lesser. Then third is, my lord, specific exclusions. My lord, those 3 entries and entries relating to them. Lord, again, my lord, the very same article first uses the word applicable. Insofar as they are applicable to Union territories, and then say entry 1, 2, and 18 of the state list and entry 64, 65, and 66 of that list, insofar as they relate to state entries. Lesser of the rigors, lesser of the test to be applied, and lesser of the threshold to be crossed while examining. Then 4, the legislative power of Delhi Assembly is further circumscribed by sub-article 3B and sub-article C of the Constitution. The parliamentary legislation can supersede the Legislative Assembly's Act in place. since Article 239AA3B and C is also part of the Constitution, this is circumscribed power conferred upon the Legislative Assembly. My Lord, kindly pause here for a minute. My Lord, what I'm trying to assist your Lordship with is this. Lord, my Lord the Chief Justice rightly remarked that for the purpose of Delhi, state list and union list, both state list and concurrent list, both are concurrent lists. Meaning thereby, the Parliament can make a law even from the state list, which is not permissible in case of federating states, which overrides the state list. Since the legislative power is coextensive with the executive power, when we read sub-article 3, subject to this constitution, would it not be, I'm posing a question to myself, subject to even 3B and C? Please, my Lord, read that. Again, my Lord, at page 35. Subject to the provisions of this constitution, then your Lordships have read, come to B. Nothing in subclause A shall derogate from the powers of Parliament under this constitution to make laws with respect to any matter for a union territory or any part thereof. So, the legislative power under A is subject to B because B is also a part of the constitution. And it starts with subject to the constitution. And C is, my Lord, supremacy. If there is a law made, then it would prevail. It's like, my Lord, 245. Then, my Lord, fifth, I'm on page 38. The fifth limitation on the power is to be found in Article 264 to 246.4, my Lord, which I have quoted. Please read, my Lord, at the foot. My Lord, the title is Subject Matter of Laws Made by Parliament and by the Legislature of the States. My Lord, hierarchical list is given. First, union, then supremacy of the state, etc. But 4, Parliament has power to make laws with respect to any matter for any part of the territory of India not included in a state, which includes, my Lord, union territory. Notwithstanding that such matter is a matter enumerated in the state list. This is the limitation on the power of Delhi Assembly and supremacy of the Parliament, which my lords have accepted in the Constitution bench. Now, your lordships, my lord, kindly, my lord, skip. I have reproduced, my lord, what the High Court has said, my lord. High Court accepted our proposal, my lord, our argument, my lord, but I'm
Yes.
Just before I take note, just for one repetition, kindly read 246(4). Yes, for my lord's consideration. I think I could not make myself clear.
Two.
Page 38, 246, Article 246.
Parliament can legislate with respect to any territory which is not included in a state.
Included in this.
I think you read
Includes,
it.
you read it, yes.
Yes. So now coming to page 41, the heart of the matter. The scope of the expression insofar as any such matter is applicable to union territories. Page 42. Lord, before I read this, Lord, let me make one statement after reading Constitution Benjamin. The majority view, not majority, it's a concurring view, my lord, but judgment of my Lord Justice Deepak Mishra, as my Lord swear, does not deal with this interpretation at all, and I'll make that good. Well, the submissions were that even majority is accepted insofar as doesn't mean anything. They have not touched upon this. My Lord, the Chief Justice of India has touched upon it. Kindly, my Lord, come to page 42, page 42. I have quoted para 316 of my Lord, the Chief Justice of India's view on insofar as. Otherwise, the majority doesn't say a word about it. And I have noted the paragraph in which para what is saying. This is not touched upon.
Where are you reading now?
Lord, page 42.
Yes, I got it.
Para 316. Lord, this is quotation from my Lord, the Chief Justice of India's view in Constitution.
Part of 71. Part of your para 70.
Para 70.
Yes, part of my para 71. But the paragraph of the judgment of CB is 316. Clause 3 of Article 239AA defines the legislative powers of the Legislative Assembly for the NCT. Subclause A empowers Legislative Assembly for the NCT to enact law with respect to any of the matters contained in the state concurrent list of the 7th schedule of the Constitution. Now, please note, this is your Lordship's finding. The ability of the Legislative Assembly is circumscribed insofar as any such matter is applicable to union territories. Learned friend, read 3 other paragraphs without giving a context of 316. The Legislative Assembly can hence enact legislation in regard to the entries in the state and concurrent list to the extent to which they apply to a union territory. So this argument was not advanced union territories versus union territory, but your Lordships were not dealing with individual matters.
No, but there again, I've used the word a union territory. I've not said the union territory.
Yes,
The union territory would mean that.
mean all also.
No. The union territory would mean the union territory which is enacting the law. A union territory means all union territories.
Lordships are right. I'm grateful, Lord. I missed that. I missed that. Your Lordships are right. Then your Lordships were very careful. But your Lordships, Lord, it never fell for your Lordship's consideration subject-wise. Your Lordships have made it very clear. All, Lord, the 3 views.
Small thing is, it might be better to read 316 from the judgment because he's only quoted part of it.
But I'll read, Lord,
Okay,
from the
hold on,
text. Yes.
This is
Lord, it is page 4. You are right. Page 4647.
Why don't we do this? Since we are all on soft copies, can we just look at the hard copy of the judgment for a moment? Others, or we have the judgment. We can go back and come back to this. We are on page 45 of your submissions. That's okay.
Yeah,
No
yeah.
problem.
It's 316.
I'll just
the main-
save our marking. Where is the judgment? Just for
Lord, it is
Volume 2.
volume
volume 2,
Just give us
four.
the key.
812. Sorry, volume 1, bookmark 59.
First one.
4879.
Convenient, volume 1.
Page?
4812 is it?
Correct.
Plus maybe 420.
Yes, we got it. मिला आपको? मुरारी भाई मिला आपको?
It's a
ये
and a half
है
paragraph.
4816 देख लीजिए.
It is over 3 pages.
4816. Tiger Mila.
Page number.
4816.
So, number what?
There are three
316.
ones.
3 1.
Hima, you got it? It's 4816. Narsima, मिले आपको? बताइए कितने लाना है?
So, my lord, the Chief Justice of India has converted all of us into this.
Actually, COVID converted all of us to.
Yes, yes.
That's really what gave us the opportunity. to-
I am, my lord, my learned friend also, my lord, admitted.
No, but I'm very happy. I was noticing even Dr. Singhvi was, reading using his.
We were, both of us were in fact struggling with thing, my lord, not notings with some selected pens of which both of us are fond of. My lord, that pleasure is.
Problem with this soft copy is that the pleasure of writing with a thick nibbed pen is lost.
That's the common.
Don't share with us. That's a different kind of pleasure.
That's common, my lord, interest.
Or writing, using your own ink. I won't name the
Using thick
council.
nibbed pens with different things.
Different colours.
You can do all that with the slide.
That's true.
Possible.
Colors are available.
You just size
The
and
thick
here
nibbed
and
pen is.
Yes, but
I won't
we can't
name-
get the thickness of the thing.
I won't name counsel, but when I was a young lawyer, we used to have senior counsel in Mumbai who used to mix their own ink.
I see.
So we had a very learned counsel who used to use use what he called burgundy.
Again.
So burgundy, he would mix the black pink. You got this ink called pink in those days. So he would mix black and red, so it became burgundy.
The delightful
What-
color because now it comes ready-made and mixed.
Now, my lord, there are,
So many shades of burgundy.
But I said
but
it.
for example,
That you are my mentor.
for example,
Mr. Mehta, I said in the lecture in the some university convocation that so far as this use of this technology is concerned, he is my mentor. I
No,
was.
but
my lord,
He
equally,
taught
I
me
must
and
say,
he
I
forced
can
me.
also,
First of all, he forced me, then he taught me. Then I started.
But he has an open mind, so that it just made it easier. We used to be sitting in our own home offices at the height of the pandemic, when everything else was shut. And you would have two sets of, one desktop and a
convenient.
laptop open. So
One has to change with the time. Otherwise, you can't pace. You can't progress in the life.
one,
Life should not be static.
initially, we didn't have a breakout facility. So what we did was, Shah and I, we used to have a separate desktop open. So we would mute the lawyers and then talk to each other about something about the case, what to do in a small matter or a big matter, whatever.